Hi, this is estate planning lawyer Michael Pevney, and in this video I'm going to talk about the 3 best ways to avoid probate. I believe the third way is the best, but you can decide for yourself. But before that, if you're interested in estate planning and want any more information, please subscribe to this channel. And if you live in California and need to get that estate plan started, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. So these are the 3 best ways to avoid probate. Now first, let's talk a little bit about what probate is. Probate is the government-controlled and government-run and court-supervised asset distribution program. So if you die either with a will or without any kind of estate plan at all, your estate is going to have to go through some kind of probate. And it involves, it's expensive. It's based on the value of your estate. So where I practice in Orange County, the average home to get it through probate would end up costing somewhere in the range of $50,000. That's 50. Sometimes I get comments in that saying like, you meant 15. No, it's about 50. 50 grand to get that through probate. And it takes a long time. It often takes about 1.5 to 2 years to get an estate through probate. So that's something we really want to avoid. So here are 3 ways to avoid probate. 1, don't die with a lot of money. Okay, that seems pretty simple to say, but in California, if you die with a probatable estate worth less than $184,500, the people you leave behind can file what's essentially called a small estate affidavit, and it doesn't have to go through the full probate process. Now the problem is that real estate values in California are very high, and that basically makes any homeowner, the huge, vast, massive majority of homeowners, not subject to that small estate affidavit. So basically, if you're a property owner in California and you don't have a complete estate plan, you're going through probate. So dying with not a lot of money is not necessarily the best way to do it, but that is one way to avoid probate. Number 2 way to avoid probate is to use beneficiary designations. Now, there are a lot of financial instruments that you can use beneficiary designations on. And when something has a beneficiary, it goes straight to that beneficiary without going through the court process, and it does not have to go through probate. I'm talking about things like a normal bank account, a regular checking or savings account. All of them have what's called a POD, payable on death, or TOD, transfer on death beneficiary, where that will, if you die, basically you show up with a death certificate and an ID, and if you are the beneficiary, you're getting control of that account. And that goes for checking and savings. That also goes for traditional brokerage accounts. Those all have beneficiaries to them, and those do not have to go through probate. So it's very important to the owners of those accounts that you put down, list, and update those beneficiaries, especially if there's life changes like a divorce, right? Because we don't want an ex ending up with some of this money, which actually it does happen. There's a lot of horror stories about that. Life insurance. Life insurance also, of course, has a beneficiary designation. That's the whole point of life insurance, that it benefits somebody that you leave behind. That stuff does not have to go through probate, which is great. Retirement accounts can have a beneficiary designation. Typically, it has to be a spouse unless they sign off that it can be somebody else. But you can also leave alternate or contingent beneficiaries. And very recently, California has actually allowed beneficiary designations on a property deed, on real estate. I don't actually recommend that because that can make things more difficult and doesn't provide for a lot of contingencies. But if you've got a house, you can actually make a beneficiary designation using a specific type of deed, file that with the county clerk's office, and then that home does not have to go through probate when you or both you and your spouse pass away. But the third and the best way to avoid probate is for the large majority of my clients, is by the use of a trust, specifically a revocable living trust. And that is this legal entity, and I've used this analogy before. It's a bucket. You put your stuff in the bucket, whether that is your house, your checking accounts, your personal property that's in your home, And even you can make the trust the life insurance beneficiary. And all this stuff goes into the trust. A trust does not have to go through probate, so it avoids the time and the hassle and the high cost of probate. But the thing that it also has as a big advantage over any sort of beneficiary designation that's an individual, even the deed to a house, which I don't like making individuals beneficiaries of, you have control. You get to control exactly how that property is distributed. Is it going to go to kids at a specific age? Do we want them to hit certain maybe educational milestones? Do we want to keep it away and maybe keep it in the trust used for the benefit of the kids because maybe we're concerned about an abusive spouse or something like that? So what happens is when you pass away, the stuff is in the trust and the trust still exists. And you, while you're alive, are the trustee to that trust, meaning you have complete control over everything in the trust. You can put stuff in it, you can take stuff out of it. But then when you pass away, the trust still exists and it is handed off to the successor trustee, the next in line. And they are required, legally required, to do what you say you wanted to happen with the property, with the stuff in that trust. And if that's to keep it away from kids, from children until they reach a certain age, maybe you want them to be 25, 30, 40, or even older before they get complete control over your home or something else, because maybe they're not super responsible, or maybe they have issues with addiction or substance abuse, or maybe you don't like the person they're married to and you want to make sure that that stuff doesn't get commingled with other marital assets and basically become an issue when they might eventually split up. So the trust, putting something in a trust, and a well-created trust that's made with the careful help of an attorney that's helping you achieve your goals, is usually the best way to do that. So those are the 3 best ways to avoid probate. Number 1, don't die with a lot of money. Number 2, use beneficiary designations. And number 3, and I think the best way, use a trust. If you've got questions about this or anything else related to estate planning, please subscribe to this channel. And if you're in California, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Thank you for watching.